when you are.
Please the court, counsel. It's Mark Sussman, I have the privilege of representing Ryan Sims. It's a appeal, and I'd like to reserve 4 minutes if I could. These parties met.
You're in reserve 5, is that what you said?
4 minutes.
4 minutes. Everybody's 4 today. What's with this?
Well, I heard them and I thought,
Okay, you might as well.
good enough for them is good enough for me. I was gonna say 3 otherwise. These parties met in law school once upon a time in Howard with the law school, both lawyers. But the pertinent facts really are the procedural timing of this case and some basic facts as to what the evidence was at trial. The wife filed her petition on October 5th of 2016, and there was about a 4-year hiatus until the final trial, which occurred on September 16th, 17th of 2020. The final judgment wasn't entered until thereafter, 4.5 years from the date of entry or from the date of filing of the petition for divorce. So there's a significantly long time period that was an issue. That plays into one of the cases, Bears versus Bears from another DCA, which found that a lengthy period of time the date of filing was pertinent in terms of valuation either.
But isn't our standard of review on that point of use of discretion?
Use of discretion, but there's clearly case law that says that that discretion is bounded. It's not unfettered. And there is a
So we got a couple issues here. We have a 4-year span.
4.5. If you would.
Yeah, and the major asset, of course, is this Merrill Lynch account.
Correct.
I mean, that's the big issue here. And so we have to determine whether that increase in the account was passive or whether it was active due to the husband's efforts and therefore non-marital. And then we probably should consider who was the cause of that delay. And we probably have to consider the fact that the husband had exclusive control of the account over the wife's strenuous disagreement with that. And then we have to weigh the experts and whether they were credible or not. Isn't that kind of really where we're zeroing in?
You know the issues.
Okay.
Yeah.
So
I was focused on procedurally in terms of the cause for the delay. Because the trial court said that my client was a substantial cause for that delay. But I want to point you to the record in terms of the fact that there was a collaborative process initially in this case. No fault to be the parties, they had a collaborative process. That was 19 months that it took because the wife walked out of 6 meetings, did not either attend or walked out of 6 particular meetings. Hoisting that delay on my client is an abuse of discretion factual. It's a misstatement of fact.
yeah, but what I understood from the court said that your client resisted every effort to provide discovery and documents about this account and other things which contributed mightily to the delay.
There's no question that the court found that my client resisted in giving the Merrill Lynch statements. However, recall, they had a collaborative process. By definition, in a collaborative process, you have 2 neutrals, one of which is a psychologist, not pertinent, one of which is a CPA. The CPA in this particular case had 19 months to review all of this particular documentation, which the trial court knows nothing about. The first step we took when I was hired in this case after collaboration, because each party has to hire new lawyers, is to say, let's use Briggs Stahl as the CPA because he already knows everything. The wife resisted that. So there's a motion that's a record that indicates that.
The other problem is that the trial judge found your client not credible, his demeanor not credible, his expert not believable, found the wife very credible and her expert very believable. So all that contributes into this delay analysis.
It contributes, however, the court's express findings are a misstatement of the law. So when you turn to the final judgment and you go to paragraph 23 of it, it says, the court says, the husband's management of the account, so the court notes that he managed the account and finds that, is not enough to warrant awarding him all of its income. So when you read all of that, what the trial court expressly says is that my client's burden was to prove that all of the—
No, I didn't read it that way. What I read the court to say is that your client wasn't believable. There was no evidence whatsoever to analyze whether the account grew to his activities or because the market was robust during that time. His own expert testified initially that everything that happened post-filing that account was 100% attributable to the husband. And then later, upon being examined more carefully, said, well, no, there was a robust market at that time. He really couldn't say what. He also couldn't say if the account was left alone that it would have performed as well. So
That's
there
not
was
the burden.
no evidence.
That's not the burden. The burden under Perry, and that's this court's opinion, is to present the evidence that there was some activity by my client that created active appreciation. Check. My client did it in multiple ways.
Well, the court also found that your client withdrew over $1 million from the account, only 600,000 of which could be attributable to maintaining marital properties. The rest of it was sort of an unknown commodity. And your own experts said that account would have been better if he hadn't taken that money out. It would have performed better.
We're not taking issue with that. But the court has a misstatement of what the law is. We have to take the record as we find it. And the record in this case is the wife presented no evidence, zero, as to what caused the increase of the account. My client, essentially, because you just, as you said, let's carve out what his expert says. My client is the only evidence to that. And this court found.
Yeah,
Well, go ahead. I'm sorry. Go ahead.
So going back to your question on 23, the husband's management account is not enough to warrant awarding him all of his income. Mr. Cheatham, after a certain length of time, finally agreed that there would be some appreciation. Not all of it was based on what your client was concluding, where they should be invested. So some income would have gone to the wife. If they had divided the account in half and she had just said, let's put it on a conservative fund and let the financial people do their thing, he could have done his. His might have skyrocketed, hers wouldn't have. But to argue that the way I'm reading paragraph 23 of the trial court's order, is that he doesn't have that entitlement.
The case law is that if a party proves that there is active appreciation because of their efforts.
Right, but that wasn't proof.
It was proved. It's just misstated by the court in terms of what the law is. Go look at paragraph 27.
It wasn't proof. Mr. Cheatham said that there would have been, this wasn't, all of this appreciation wasn't due to your client's
But it
activity.
doesn't have to be. That's my point. That's a misstatement of the law. If you look at the Cato Fumo case, there's a 7-year delay between the date of filing and the date of the petition. And this is a business, a construction business.
But this wasn't all his money. At this point, his name's on it, but why would he get all of the appreciation?
So my analogy, Cato Fumo, is a construction business. The husband is the titular head of that, obviously. He's not doing all the construction, but his management of the business is determined to be active. You don't have to prove that every single iota of the appreciation is because of his direct efforts. That's a misstatement of what the standard is. For instance, Perry, the stock option.
But the judge even said that your client wasn't credible when they were asking, when Mr. Cheatham responded, when your client was asked about this, he couldn't give direct answers. He was evasive on what exactly it was that he did.
He was
Simply stated, the court found your client didn't meet his burden of proof. That's what the court found.
because the court misapplied the law, applied it as you're indicating, that he had to prove all of the appreciation was marital in terms of his labor, which is not what the law shows.
The court found the court could not determine whether or not this account would have performed better if it was just passively managed, or there was no ability for her to identify his responsibility for a single dollar.
I disagree with that. Let me tell you why. It was the wife's responsibility, if she wanted to say that it was appreciated because of passive forces, to prove what those were.
Your client's own expert testified to that.
But there was no quantification. We have to take the record as we find it. The record as we find it is that my client changed the investments, determined what to buy and what to sell. My client met with the financial advisor. My client subscribed to the Wall Street Journal. My client monitored the market on a daily basis, and my client specifically shifted 2 tech stocks from mutual funds and other various market type funds into something very specific that causes appreciation. That's all his labor. It doesn't have to prove what the passive appreciation would have been so that the court can only give him this.
Yeah, I mean, I understand your point, but
It's not my point, it's the court's point. And here,
Isn't there also a presumption that it's a marital asset?
It's a marital asset.
There's a presumption that its growth will continue as a marital asset.
and the absence of any proof of divorce. But here we have direct proof, which the court doesn't discount. The court does say, as Judge Starzl says, that my client was vague or evasive, but it doesn't take away from the fact that the court found that he had effort. The court specifically says it here.
But the court, what the court didn't find was that all the growth was due to that effort.
But that's not the standard of law. Under Perry and Calafumo, you don't have to prove 100%. You have to prove that there's marital effort, and then the burden shifts to the wife to show what the passive would have been, is what my argument is. I think this, on the face of the Calafumo case and the Perry case, that's exactly what is the standard. In the Perry case, we're dealing with stock options in a particular company. All of the company's efforts aren't in that particular litigant's hand. So other people are passively causing
In a
appreciation.
construction company situation, sure, they could have said, well, I'm not gonna do any more of my effort because this is really my work. I'm going out there and I'm putting it forward because I have special skills. In an investment context, I think what the trial judge was saying and asking here is, we all know whatever was going on in the market is a known quantifiable factor. So there could be some gain. And your expert, Mr. Cheatham, even agreed, yes, there would be something, but we don't know
Correct.
what that would be.
We don't
And
know.
you're wanting to put all of that at the wife's feet as though, okay, it's zero. If you can't say what the gain would be on your $3 million or 3.8, whatever it was, then it's zero. Is that what your argument
You
is?
have to have there's a burden of proof here. So if the wife wants to contend that something's passive, she can't just say, well, passive occurred, but I'm not gonna quantify it. She didn't ask Mr. Cheatham to quantify it. She didn't bring an expert in to quantify it. My client specifically testified as to what he did, and his effort should be rewarded because that's what the law says. So if there's an absence of a particular finding, it's because the one litigant chose not to present proof of that. And I would contend the law is clear on these points in terms of how the court should handle it in terms of the.
Can I shift gears on you? Because
Yeah,
I'm more interested in the equalizer payment coming out of the Merrill Lynch account and its tax impact.
well, there's a tax impact, we both agree,
Well,
it's
maybe,
minimized.
yeah, maybe so, maybe not. You could sell stocks that have not appreciated and there would be no tax impact.
Even wife says there's a particular tax impact, she just minimizes it. So the court didn't consider that. The court said, you gotta take it out of this account, but doesn't do the math. So that's not,
What the
it's
court,
clearly error in terms of what the law is.
the court stated to do it in, I forget the exact language they used, but basically a tax neutral basis. So
It's not possible.
it is possible.
The wife even
If you
says I
have,
would agree.
when you're dealing with capital gains, and again, this is outside of, I mean, the judge said to do it in a tax neutral way. There are ways to do it based on stocks that have had a gain, stocks that haven't had a gain,
If there
which
are
ones
those.
are you gonna sell? And that all depends on when you sell it. But at the point in time, there was testimony that yes, there was losses. The husband even testified to it. So, you
But
know,
we don't know if there was
he's
enough
saying there would be an
loss.
$83,000 gain. And that would require the basis to be zero, where in a stock environment, it wouldn't be
You
zero.
don't know that it could be offset. You're guessing. And I'm saying we have to take the record as it is. There's no evidence as to what the stock effect will be in this particular case, but we know there is one. The wife herself,
Well, we have to take the record as it is. We
Yeah.
don't know that there is.
no, we do know there is one because our expert testified as to what the tax effect would be. And the wife or the former wife in her own brief quantifies it. She says it's like $7,000.
But there was discussion of the basis, and the basis could be, you know, any number, but you're assuming the basis would be zero because it's 100% effect. So that it's
I'm
all
saying it
gain.
could be. I'm not saying it will be. I'm saying the court didn't account for it. The court didn't
The
charge the
court
path.
did allow, the court accounted for it by saying, do it on a tax neutral basis, you know, as much as you can, do this. So it would give him, so that she doesn't come back into court and saying, wait, he sold all the ones that are lost and I should have got some benefit of that. Then you can take those, you can sell those stocks that you have a loss in, don't take the gain, do the payment to equalize it and move on.
No, I think procedurally, what you're suggesting is an error. First, it's divided in half, and then from his half, he's supposed to account for this additional payment. So it's already been carved apart.
Yeah, but when it's carved apart, some of the stocks
How
have
do we know?
appreciation, some of them don't.
How do we know that?
Someone,
We don't know that. The
well,
court knows
the
that
entire
there's a-
testimony throughout your clients talking about buying and selling is talking about some winners and some losers, and your expert, acknowledged that there was different holdings. So even if there was only 2 holdings in there, one of them is going to have more appreciation than the other, and someone's going to decide, wife gets half, husband gets half. So what the court's saying is, you can look at this as much as you can in a tax neutral way, because you're going to have to make this equalizing payment so he can take some of the stocks with the loss.
And you're.
But you're assuming that it's gonna net out to
You're
zero,
out of time.
which the former wife even acknowledged.
Mr. Sessoms?
I'm sorry.
You're out of time, but you may use your remaining time as you choose. I just want to let you know.
Thank you very much.
Morning, police court. I'm Helen Ware. I represent Margarita Sims.
Look, can we pick up where we just were?
Yes, I would like to. So let's start there. The court took this account and said, and this was based on, and it's in the final judgment, it was based on the testimony of our expert and the agreement of Mr. Sims' expert that the tax neutral way to divide this count is to divide each holding in half. So if you have 50 shares of a particular stock, you bought it on a particular day, that all has the same basis. We're going to divide that holding in half. And if you look at the final judgment, every single holding was to be divided in half. And what that means is each of the parties have exactly the same tax effect. What Mr. Sims seems to be complaining about is that he is going to need to sell some of his half with half of the tax effect. And so he may experience some of the taxes sooner than Mrs. Sims. There's nothing in the case law that suggests that time makes any difference. In any case, you award assets to people, they may sell them at different times. If you equalize the taxes, you have done everything you were supposed to do.
And I think the facts, didn't the facts establish that he has enough other assets actually to make the equalizing payment without liquidating any of the stocks?
He has other assets, but the payment was ordered to be made out of that account. And it was ordered to be made out of that account clearly so that we could be sure it was paid. But he buys and sells stocks all the time. He testifies that he buys and sells stocks all the time. So he is used to selecting, he testifies that he selects stocks to offset gain. He'll sell stocks at a loss. And no, I don't think we know what exactly
Well,
array
that's,
he
I
will
think
have.
that's our problem is we don't know, and that's Mr. Sesson's point. We don't know. He's been ordered to liquidate part of that account. We don't know if there are stocks that have not appreciated or actually in the negative category sufficient to absorb all the tax impact. We just don't know.
Well, we don't. I mean, I think, Mr. Sessoms points out that in our brief, we point to some stocks that had just at the time of the final judgment, or at the time of the final hearing, excuse me, per the record, documents in the record had only 7,000. He could have had $7,000 in gain, $7,000 in gain, on which he's paying,
That was a fairly arbitrary number, wasn't it? The
Which?
7,000?
It was subtracting the value from the basis. So it was the records are in the
Okay.
in evidence. So you could subtract it and determine exactly what the gain was. If that was the gain as of the date of final hearing, it could be something completely different today. So I'm not suggesting that that's the amount, but whatever it is, Mrs. Sims will be receiving the exact same tax effect. So it's already been equalized. Typically when a judge does a final judgment, they might say, I'm going to give you this asset, and it's, say, a pension, and we're going to tax affect it, because when you go to sell it, we know there's going to be some taxes, and they put the tax effect on there as a negative. Or they have something else and they have a liability or negative. they put that on the chart. People can turn around and sell it the next day and experience a tax right away, or they can sell it, down the road and experience a tax later.
From a tax neutral standpoint, couldn't this be accomplished just through the accountants identifying whatever is sold to make the equalizing payment to be included as part of that year's taxes divided between the two of them? I mean, if they're still having joint tax returns, or if they're
Well-
married filing separate, it would still go on their separate
At
returns.
this point, we're a couple of years since dissolution of their marriage, and so they can't be filing joint
Would they be
tax.
married filing separately, or, well, the
They're
dissolutions happen, so they're
divorced, so
separate,
they can't be
but it was
filing
an account.
So there may have been other ways that it could have been done, but one of the things that we pointed out in our brief was they didn't provide another way. So the case law is that if the court is aware of a tax effect, the court must take it into account. But the parties have an obligation to provide the court with some basis for what the tax effect is, and so that the court can do something with it. In this
So
particular.
summarize what the ways that, because the judge clearly said that. So to Mr. Sessom's point, how is it that you would say that this gets accomplished? So that the judge knew that there's a tax effect, it's got to be addressed. What ways are you saying were available for them to accomplish that?
What I'm saying is both accountants agreed that an appropriate way that would equalize the tax effect was to divide the account holding by holding, so that both parties have the same basis. And both parties will have the same tax effect. And,
Except that he has to sell this to do the equalizing payment. That's.
but
what
if
we're
she
up
ever wants to use the money, she has to sell to her. If she ever wants to do anything that, other than have it sit there in an account, in order to use the money, each of them will have to.
Well, the problem with that is that she's not ordered to do that. He is. So,
I understand. So I don't think there's any support in the case law for a suggestion that the court must consider not just the tax effect, but the timing of it, and give somebody some sort of preference based on the timing, if you know what I'm saying. Like say, there's some sort of financial equalizer or something because of the timing.
But this payment had to be made right then. That there wasn't a choice
Right,
to do it down the road.
right.
And you're
That's
saying
correct.
the accounts, all of the stocks had to be divided 50-50, which means the basis in all of them are going to be equalized. If he's paying an extra $360,000 out of that to equalize things, then that would seem to indicate there's a difference then, that $83,000 gain, unless you identified which stocks didn't have a gain, some that had a loss, that they could sell those out of the portfolio.
Well, remember that the $83,000 is assuming that the basis was zero in whatever he's selling, which is not a good assumption. And there's,
Right.
I don't know that there's any stocks that have a basis of zero. So that number isn't correct. And my client is going to experience that someday. So it wouldn't be fair.
Well, out of her separate holdings. I mean, I'm only looking at the tax, the $300,000 payment. And I agree, your point's well taken, and it jumped out at me that, 83,000 would be a bizarre, that would be a penny stock you bought for a penny, and it's now worth whatever
So
to even
it's,
get close to that.
no, I noticed that in no way has the husband or his counsel suggested how we could somehow equitably take into account the timing, like somehow there's a time value of money. Is that what they're suggesting? And so because he is going to experience this liability at the time that he pays for the equalizing payment, he should have some credit for that. I mean, the only fair way to do it, I suppose, if you could decide that they both had to liquidate the stock, they both had to liquidate whatever amount of stock you need to liquidate so that she's experiencing that tax effect right now too. But that seems beyond what a court would normally do. Court normally says, you know, I've tax affected this for you. I've accounted for the taxes for both of you. I have subtracted it from what you're gonna get. And so it's already been subtracted in a sense from what the husband's gonna get, that tax. The only difference is the wife, who's also had it subtracted, may not have to pay it right away because it may be down the road. Of course, it may be more when she pays it. Tax rates may go up. You know, so we can't account for every single thing. And courts generally don't. They don't say, I'm going to account for these taxes. And then because you're likely to have to pay those taxes sooner than you, we're going to have some sort of accommodation. He's already been credited by equally dividing the tax burden. If he were to get some additional money to pay the taxes or something, you know, if he were to transfer stock to her, he would need to transfer the stock in an amount enough for her to pay the taxes. Otherwise, she isn't getting her full $340-some thousand. And they've already taxed both of them. Both of them have had the tax account.
So isn't the bottom line here is there's no quantifiable amount? We don't know whether there was a loss or a taxable gain or not.
Correct. And here's what court, you know, I do, you know, and I had notes where I was going to talk about, you know, what Mr. Sessom said. Just suffice it to say, I don't agree with his characterization of the law or the facts and some of these other subjects. But one of the things he mentioned was the collaborative process. I do a lot of collaborative divorce. And what we do is we always try to choose assets that are the same, that will be taxed the same, and divide them equally when we can. So if you have a retirement account, instead of trying to guess what the taxes might be on that retirement account, we say, let's divide it in half. And then everybody is coming from the same spot. And, you know, remember that Mr. Sims is only going to have to pay her $340,000. I shouldn't say only, but primarily because he used marital assets.
Yeah,
During the
if all that's
process.
declared a gain,
Yeah, I mean,
that's where
this,
the 80-some thousand comes from.
and okay, he's gonna have to liquidate things maybe sooner than he would like, maybe not. He says he's buying and selling all the time, so.
Can I shift gears? Because
Sure.
we've spent 11 minutes on this issue. It's a
Sure.
bigger issue we haven't even talked about yet.
Sure,
As you heard Mr. Sessom argue that the court applied the wrong law in determining this valuation date issue, and that your client never brought any evidence forward that the appreciation of the market was due to passive forces, and they put the burden solely on the husband to show that his efforts are the ones that cause the account to increase. You want to address that issue?
sure. So first of all, I think there's a little bit of mixing of apples and oranges here, because this is a question solely an abusive discretion question about choosing a valuation date, okay? It's not about marital versus non-marital. That's a different question. That's governed by statute. That has a different standard of review. You know, one of the cases cited by counsel for the standard of review for evaluation date, the Roth case, which is a case out of this court, also mentions in passing standard of review for marital versus non-marital is a de novo standard of review. And we're not there. We're not, so many of the cases that counsel cites are addressing a marital versus non-marital distinction. We are just addressing whether the court picked the right valuation date. And not just whether the court picked the right valuation date, but whether it was so crazy to pick it that it was an abuse of discretion. And it wasn't. The court found that it could not say that any portion of the appreciation was due to Mr. Sims' efforts. It's in the final judgment. She says, to what extent, if at all, his efforts caused appreciation. No finding that there was any appreciation caused by Mr. Sims. The court went out of its way to point out in the early part of the order that the court does not have to accept the testimony of any witness, even if the witness is uncontradicted. The the court spent almost an entire page explaining how it found Mr. Sims not credible. The court found that there was that it did not have enough evidence from which it could find that any of the appreciation was marital. I mean, was due to Mr. Sims. Any. And as you pointed out, Judge Morris, the court also noted that, you know, some of the appreciation was lost by the husband's efforts because he took marital funds and spent them on non-marital things, and those funds were not available for appreciation.
Were those funds ever accounted for anywhere?
Well, they're essentially how we end up with the equalizing payment that's due. I mean, not dollar for dollar, I don't think, because there were a number of things. There are retirement assets, there are some other assets, there were credits given to Mr. Sims for some of the money he spent that was spent on marital things. There was credit given to Mrs. Sims for money that she spent on marital property.
But at least some of that would have been assets that, had they been in the account and been managed, would have inured to the benefit of your client.
And would have
Correct.
appreciated.
Correct, because I think the testimony was crystal clear from the accountant, well, crystal clear once he was pushed, that the market was growing during this time. I mean, the market, we all know that. The market was growing during this time period. So the market's growing, there's appreciation all around. And husband takes some money out of the account without permission, contrary to the local order that prohibits it. And that doesn't experience any appreciation and provides no analysis from which the court could find that the appreciation that he otherwise saw in that account was due to his efforts. She pointed out that they had an advisor, that they were paid $150,000 during that time period. You know, husband says he had philosophical discussions with the advisor. I mean, the court did not find the husband credible, did not find that she could make a ruling that any portion of the appreciation was due to him. She didn't find that she knew it wasn't due to him, but he focuses on the fact that once he proves any portion of it's due to him, now it's up to my client to prove that it's not. That's also incorrect under the law. I mean, he didn't prove that any portion, he did not convince the court that any portion of it was due to him. She says she doesn't know if it was caused at all, those are her words, at all by his efforts. But he also mischaracterizes the law. He takes law that has to do with this marital, non-marital distinction. That is a way that under the statute, the marital assets include the enhancement in value and appreciation of non-marital assets resulting from the efforts of either party during the marriage or from contribution to or expenditure thereon of marital funds. It's in the statute. That is a marital asset. And he's trying to say that there's all the case law that discusses that should be flipped and looked at in the reverse as I guess, to make something a non-marital asset that was a marital asset. But there's no corresponding section in the statute on that. And if we were talking about whether this was marital or non-marital, it would all be commingled. This isn't a question of marital versus non-marital. And all the cases that he cites that are making a distinction between marital and non-marital are inapplicable. The only cases that are applicable are cases that are talking about choosing a valuation date, which is completely a matter of discretion. And the only cases cited in any of the briefing for discussing the valuation date that involve reversals are cases where the court didn't take into account changes that had occurred between the date of filing and the date of trial. And they used the date of filing when they should have used the date of trial. Here the judge uses the date of trial. And there's cases, you know, there's a case from New York called Wegman that is cited by several of the cases that are cited. And Wegman goes on and on about how a long delay like that suggests using the date of trial, not the date of filing. And there are cases, so in Wegman, they reversed, that's a New York case, but they reversed the use of a filing date instead of a trial date. Perlmutter is a Florida case, they reversed the use of a filing date instead of a trial date.
You're
And
down
then-
to 1 minute, just so you know.
Okay, and then the Catalfumo case and Perry case, which Mr. Sims relies heavily on, are simply affirmances of a trial court's discretion to use a filing date. Well, all it says is that the court was able to use the filing date, and the court was able to use the filing date in those cases because the gentlemen in those cases who worked in the business, not they were enjoying the ride in the market, not that they were somehow enhancing passive appreciation, but they were working in businesses, a construction business and can't remember the other business, maybe a paint business. They were working in the businesses day in, day out, and in both of those cases, there was a finding that it was not passive appreciation. Thank you very much.
All right.
Please affirm.
Thanks. Mr. Sessom, you have 4 minutes, sir.
Thank you. Council suggested to you that the final judgment says that the court expressly found that the court couldn't find that any of the increase in value was due to the husband's efforts. That's a misstatement of what the final judgment says. If we look at paragraph 21, it notes that the husband contends that all of the post-filing growth was directly attributable to his efforts. The court doesn't comment on that. It doesn't make any decision as to whether that's accurate or not, except it goes on in paragraph 23 to say that the husband's management of the account, and the court is expressly stating that as a fact, is not enough to warrant awarding him all of its income. So what's sticking in this court's craw is awarding him all of the income. The absence of proof is on the other side of the table. That was a choice that they made. The evidence could have been different, but it wasn't. In terms of the abuse of discretion standard, it is crystal clear under Florida law, if there's an act of appreciation, that the date of trial is what the trial court is to use. It's not a discretionary matter unless there's conflicting evidence. The date of trial is what the court's to use if it's passive appreciation. That's the Perlmutter case. So when counsel suggests that it's all up in the air and it's a jump ball, that's not accurate. Trial court's discretion is bounded, and we need to look no farther than the Byers case, which dealt with a 2-year period when litigant, an airline pilot was in rehab, where the court found that the use of the date of filing was an abuse of discretion. There's case law on abuse of discretion, and that is when you don't use the Perlmutter standard. In terms of the recognition of the tax, as Judge Stargill suggested, we just used the best case scenario for us, that there was 100% gain. The recognition of tax effect is at the time of sale. It was a 4.5 month gap from the date of trial. Counsel says, well, we used 7,000, that was the date of trial. We didn't get the final judgment until 4.5 months later. It's a moving target. So what the court should do, if the court's going to remand on this particular issue, is to remand and say, you need to take into account the tax effect on that 300,000, since you told him he has to sell out of this account to give her the money. Whatever the tax effect is, you need to give him a credit for that. It's going to reduce the $300,000 by that amount. So when counsel suggests we don't have a method to do it, that's a clear method. Why we're going to have both of them sell it all or imagine that they sell it all doesn't make any sense to me. It's the issue of husband sell this and give her the $300,000. If the court ignores the first issue, that would be the number. If the court agrees with us on the first issue, that won't even be the particular number. I would also, and by the way, when the court dealt with this, well, you didn't abide by the standing order, there's no proof on what the account would have appreciated for that portion. Again, they could have attacked that, but did not. So for her to suggest that somehow that justifies ignoring the absence of evidence on their side is nonsensical, because there's no evidence as to what effect that had. There's just a notation that he didn't abide by that particular order in the court's mind. There's an argument to the contrary, but the trial court found that, we're stuck with that, but it's without effect. So that shouldn't go into the court's analysis, because that's not what the law turns on these particular issues. And then lastly, we'd ask you, neither of us have dealt with the issue of the hourly membership. And the wife didn't live there, my client's the avid golfer. I'd ask you to know that that's an issue as well and pass on that. So thank you for your attention and for your inquisitiveness, and I appreciate your time.
Thank you both very much. Your arguments and briefs were very helpful to us.
Have a good day.
I just have a quick point of personal privilege on the collaborative law issue. I had taken an interest in it years ago, and this is really my first experience. I thought it was all working well. Please just tell me that many of the cases don't end up like this.
Almost every case that I've worked on, I think one case that I worked on ended in an impasse early on, in part because the lawyers were probably not as experienced as they should be, and in part because the parties had probably some mental health issues. But just about every case ends in a resolution, and it's wonderful, and it kind of changes how they work with each other thereafter, right? Because they've come to this resolution that they both are reasonably happy with. I mean, which is different even than mediation, because in mediation, you go in and everybody gives things up till you get to a common denominator, and everybody feels like every client, you probably experience this too, you're like, why am I giving everything up, right? You're in mediation, why am I giving everything up? And both sides are doing it, but your client's only seeing it. In collaborative, you don't have that, because you're building from the bottom up. You're saying, okay, we're trying to get everybody what they need. How do we do that? How do we arrange this? So it's really a wonderful
Well, it's good to
process.
hear that they're mostly working.
Well, a lot of it depends on the quality of the team. All of the, the mental health person, the financial person, the
The better the
lawyers.
team, the better the result.
The better the team, the better the result.
I'm a trial lawyer, so I see a lot of blown up ones, but I've had some success stories, but more than 50-50. But the team is critical.
Yes, the team is great,
Thank you.
unfortunately.
Our next case is Van Sant Law and versus Air Isaac.